Now, Constitution Bench of the Supreme Court is in fact hearing the case of the electoral bonds, where they're questioning the SBI on why more details of the numbers related to the bonds were not released. Let's listen it.
Before us,
no, I have got it with
I've made myself.
The entire judgment.
One second, you wait. One at a time. Sorry, Mr. Raghi. Yes.
No, my submission is the entire judgment has been rendered behind the back of the public at large. This judgment doesn't constitute justificator. This judgment doesn't constitute justificator.
1 second.
Yes.
1 second.
This judgment is void.
Please listen to me. You're not, 1 second.
I am a citizen of this country.
1 second.
Yes.
Don't shout at me.
No, I am very soft.
Please listen to me.
Yes.
This is not a Hyde Park corner meeting, okay? You are in the court.
Yes.
You want to move an application?
No, my lord.
File an application. What I told Mr. Rodgi applies to you.
No, my lord, the question is, my lord,
there's no question you've got.
My friend has come.
Mr. Nedumbara, 1 second.
Yes.
You've got my decision as Chief Justice. We are not hearing you. If you want to file an application, move it on the email. That's the rule in this court. No further.
We will go by what your lordship.
All, please.
Whatever your lordship says, we will go by that.
We want another contempt notice.
No, my lord, your lordship will go by
You have
whatever
had
your
enough
lordship
to
says.
Bombay.
Only I have said what I wanted to say. That this judgment is rendered behind the back of the people of this country. It doesn't bind us. It doesn't constitute. It is not a representative.
Do not, please, once we have said no, please move the application by email.
What your lordship says.
Do not continue and persist.
Yes. I only said it was not a representative proceeding.
You are
all the way come from Kerala.
You are obstructing in the administration of justice.
Pardon, my lord?
You are obstructing in the process of administration of justice.
The entire judgment is against behind the back of these people. Parliament has been rendered
Hey,
irrelevant.
that's all. That's all. We heard that. Please, that's all. You made it.
We are in a democracy.
We will not hear you till you follow the procedure prescribed.
We are filing it.
Please do.
We are filing it.
Please do. We'll consider it afterwards.
Yesterday at 10 o'clock. My friend came from Kerala to took a 1 o'clock flight. Be kind to us. Be kind to
That's
us.
all, please. We will not hear that.
Democracy.
Please call for the application. Please follow the application.
Democracy.
My lord, may I mention, my lord, my petition for so moto that is pending. Whatever lordship want to do, that do only. I will not disturb lordship.
Mr. Agarwala, apart from being a senior counsel, you are the president of the SCBA.
Yeah.
You should know the procedure. You have written a letter to me asking me to invoke my suo moto jurisdiction.
Yes, my lord.
No locus to mention
So
anything.
that I should not disturb lordship. We should not waste the honorable time, court's time. That's why.
Lord,
Only that.
These are all publicity oriented stunts. We will not permit it.
Handmade of
Whatever lordship feel better.
Mr. Agarwala, please keep it at that. I may have to say something more, which will be perhaps a little distasteful. Please close it.
It is enough now.
Also senior to your
It
lordship.
is enough.
65-year-old man, Lord.
Be kind to us. We are very polite and begging with your lordship. Your lordship has a soft language.
We have been telling you that you are interfering. You are obstructing us.
No.
Now, if you don't stop, we will have to.
When we are not heard and we feel threatened. Sorry, Lord.
Follow the line.
Yes, follow. Yes, hearing now. We issued notice on the last occasion to State Bank of India. Mr. Kapoor, you are appearing? You are appearing
Mr. Salve is also there.
for the State Bank?
That's right.
Yes.
I appear for the State Bank.
Yes. Mr. Salve, in our order in the judgment which we delivered, we had expressly asked State Bank of India to disclose all details. The language of the judgment was all details have to be disclosed. Therefore, that includes the bond numbers as well. So, let SBI not be selective in the disclosure of details. We intend to clarify that it shall disclose all details, including the bond numbers, and every part of the information which is in its possession and custody. Don't wait for an order of the court. We banked on the fact that the State Bank of India would be candid and fair to the court.
But whatever your lordship say, if your lordship say bond numbers, you can disclose the bond number. There's no problem. Somebody can screen them.
Why has the SBI not disclosed?
I wanted to tell my lord how we understood your lordship's judgment. Give me 5 minutes only to explain our conduct. We'll, of course, if your lordship say give anything more, everything will be given, but there's no question.
SBI's attitude appears to be, you tell us to disclose a particular detail and we'll disclose it. That's not fair process.
But how we understood,
The SBI requires, this is the judgment of the Supreme Court. As chairman of the State Bank of India, I'm duty bound to comply with the judgment. I will disclose every part of the information which is in my custody as directed by the Supreme Court. Because when we said all details of the purchases, that means every conceivable detail which is available with State Bank of India. And we clarified by saying including. That should be, I mean, State Bank of India has the best legal advice open to it.
may I not take your lordships to the three orders to how we understood them? My lord, your lordship's first order was 12th April 2019.
Yeah.
And we have, for convenience, my lord, we have put the three orders together. If your lordships just see that. We'll give everything, there's no question. Just to explain that it's not that the impression which is being created, my lord, is that State Bank of India has been playing ducks and drakes with the court. I just wanted to clear that up. If your lordship sees the 12th April 2019 order in paragraph 16, but I had asked my friend to make a little compilation of the orders so we could show them easily. Your lordship has not
Yes, para 17, right?
para 16, my lord.
16. You got this? Yeah.
Yes.
Yes.
This is the interim order my lords had been pleased to
Yes.
make. After my lord noting all the changes, the court would have to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same ensures adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require.
Okay, all right. Can we just see para 15 again, Swan?
Yes. The court therefore has to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same would ensure adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donation through the electoral bonds to submit to the Election Commission of India and seal cover detailed particulars of the donors against each bond. The amount of each such bond and the full particulars of the credit received against each such bond, namely the particulars of the bank account to which the amount had been credited and the date of each such credit. So, my lord, your lordships felt this would ensure transparency, that you give all this, but you keep it in a sealed cover. So, my lord, a political party doesn't need bond number. If a political party comes and says, I have received so much from so-and-so, that gives the requisite
Already
details.
take it, you're not arguing a case for a political party, right?
No. On the contrary,
Caring for the state.
I'm saying the reverse. I'm so sorry, I'm saying the reverse. But if a political...
Para 16, Mr. Salve, was relating to the political parties who had to submit the data to the
Correct.
to the election commission.
Correct. And they have. And this has...
No, that's a separate issue. Whatever they have declared or not declared, that's a separate issue. But as far as the judgment of this court is concerned, because you
Yes.
were supposed to...
I'm coming in a minute. If your lordship will just give me 1 minute how we understood it. Para 16, with, as my lord has therefore noticed, only required the political parties to give all these details. And these details have been given, my lord. If they have not been given, that's between the ECI and the political parties. As my lord the Chief Justice said, I'm not preparing for a political party. Then, my lord, para 17 was the mechanism. Your lordship said details will be furnished in respect of electoral bonds, the details of such bonds that may be received by a political party. Up to a date for issuing such bonds as per the ministry, that is February 19, will be submitted on or before 3rd of May 19. The seal covers will remain in the custody of the ECI. So, my lord, we had no role to play. Your lordships had put this mechanism in place. In your lordship's judgment, your lordships dealt with the diverse aspects, including the need to preserve some degree of anonymity, and your lordships will not mark that in para 125, where your lordships discuss the electoral trust as a alternative to this system. And in the conclusions, which are para 218, if your lordships have the compilation, it would be PDF page 76.
Yes.
Your lordships will not say we direct the disclosure of information on contribution received by political parties under the electoral bond scheme to give logical and complete effect to the ruling. On 12th April, the court issued an interim order directing that the information of donation received from donation must be submitted by political parties. The court directed political parties to submit detailed particulars of donors against each bond, the amount of each bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date on which such credit has been made. I'm only not saying this to explain how we understood the order. So this correlation between which political party has received money from whom comes in here, because the political party says, I have received so much money from so-and-so. Then it says, during the course of hearing, Mr. Sharma said that the ECI has only collected information on the contribution made in 2019 because of para 14 indicates direction was limited to contributions in that year. Your lordship then clarify para 13 and 14 of the interim order are extracted below. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donations through electoral bonds to submit to the Election Commission and sealed cover particulars of the donors against each bond, the amount of each such bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date of each such credit. The details will be furnished forthwith in respect of electoral bonds received by a political party till date. The details of such other bonds as may be received up to the date fixed for issuing such bonds, including February 19, May 19, will be submitted on or before May 19, and the seal covers will remain, etc. Then your lordships clarify, para 14 does not limit the operation of 13. 13 contains a direction in unequivocal terms to political parties to submit particulars of contributions received through electoral bonds to the ECI. Para 14 only prescribes the timeline for the submission on the contributions when the electoral bond should be done. In view of the interim order, the ECI must have collected particulars of contributions made to political parties through electoral bonds. In view of our discussion, the following directions are issued. The issuing bank shall stop issuance of bonds, which was done immediately. The SBI shall submit details of the electoral bonds purchased since the interim order by the court till date to the ECI, fully given, Manoj. Details shall include the date of purchase of each bond, the name of the purchaser, and the purchaser of the bond, and the denomination of the electoral bond purchase. All these details are given. SBI shall submit details of the political parties which have received contribution through bond since the interim order till the date of the ECI. SBI must disclose each electoral bond encashed by the political parties, which shall include the date of encashment and the denomination of the bond. Now, as we therefore understood this, the political parties have come and said we have received so much from so and so. Are the details which we will give will make the database complete so that we have the who purchased, when he purchased, and when they have got. If the numbers are to be given, we'll give them. There's no problem. So, according to us, the data.
Mr. Salve, I have a few questions. First, yes. Tell us in what format is the data on the purchase and redemption of electoral bonds stored by the SBI?
So, as I had explained in the application which we filed, because at that time we were functioning under the edict of anonymity, which had not been stayed. So, at that time, we were directed to preserve anonymity, including we had to take measures that within the bank.
Format. What is the format in which you maintain the data on purchase and redemption of electoral bonds? In what format do you store it?
In two silos. Your lordship noticed that in the next order. So the data is maintained in two silos.
You store it in three silos. From your application, it emerges now that you do it in three silos. The first silo is the bond number. The
bond number is only on the bond.
And the third is the redemption.
My lord, bond number is only on the bond, and it cannot be read except through under a UV light. That was only done, my lord, like authentication, because it was a bearer bond. That's what was sought to be.
What's the purpose of the alpha? And second question, what is the purpose of the alphanumeric?
The alphanumeric is the bond number which is visible only under a UV light.
Is it only a security feature or is
A security feature entirely.
in the audit trail? Do you also?
No, my lord, audit trail is separate. That's why we do the entire KYC. In the KYC, we have a bond unique number. It's not the bond number. You have a marker number of a client.
Third question.
Yes.
How does the redeeming branch?
Yes.
How does the redeeming branch
Yes.
match the electoral bond number to determine that it is not a forged bond?
So they were not. That's what I'm saying. When they received it, the person encashing it gets it. He sees that it's a valid bond because you see the security feature. You don't keep a record of it. The physical inspection.
While redeeming it,
Yeah.
the only way you can ensure that it is not a forged bond is to match the alphanumeric. Without
There's nothing to match. It's like seeing a currency note. It's like seeing a currency note. You know that's
the
a currency note.
alphanumeric.
Yeah. But
Cashed in the last 15 days because it's only valid for 15 days. So therefore, they will have to also match when was this bond.
I think Mr. Bhushan should hold his peace for a minute.
Fourth, what is the information that you see when you scan the alphanumeric?
Malad, you see a number.
The details of the purchaser and the bank which issued the bond when you scan the bond?
No, Malad. That's what I'm saying. That correlation was not kept for the reason it's like this. Mr. A or Mr. B come and buy the bond. So they go to branch A. They do the entire KYC information is done, their bank account details, etc., everything is done. That is silo 1, if one may so call it, which is nothing near Rothschild's. That's been fully disclosed. That bond finds its way into the hands of some political party. We don't know who gives it, how it goes, how many hands it changes, it finds its way in the. We get
that questioning is taking place regarding the alphanumeric number, that data that wasn't provided by the SBI. Well, the tough questions being raised to the SBI in the Supreme Court.
But most serious things will not start happening thereafter. Lord, those before the court started giving press interviews, deliberately embarrassing the courts, my lord, and there is, Lord, a non-level playing field. My lord, on this side, nobody can rebut that. Neither government can do, nor state bank can do, nobody else can do. Thereafter, my lord, a barrage of social media posts, my lord, at least intended to cause embarrassment, started during these 2 days. And thereafter, my lord, now it's anybody's field. It's an open field. My lord, statistics, your lordships are aware, can be twisted in any manner the person wants. It's a matter of, my lord, intelligence of the reader to understand. Now, my lord, based upon the twisted and other statistics, my lord, any kind of my lord, posts are being made. I know, my lord, your lordships cannot control them. The question is, would your lordships, my lord, consider issuing a direction which has a necessary and inevitable fallout, which the court would not be able to control? Lord, that saying Mr. Rodgi gave this money to this, then they have their own conclusion.
Mr. Solicitor, we are only concerned about enforcing the directions which we issued in clauses B and C of para 221.
That's
as judges, we decide according to the Constitution.
correct, my lord.
We are governed by the rule of law. We are also the subject matter of comment in the social media and the press. But surely, as an institution, our shoulders are broad enough.
No, I'm saying, I'm not, my lord, for a second.
Our court has an institutional role to play in a polity which is governed by the Constitution and the rule of law. That's the only job.
My lord, my purpose is to inform your lordships that there is something else playing out which neither your lordships intended nor the scheme intended. And, my lord, kindly bear that fact in mind. On 11th of March, my lord, we thought that we are ad idem, that this information would help the voter to take a call whether to vote in favor of a particular party or not. My lord, thereafter this started in a very systemic.
All right. What order?
One fact.
Can I assist you?
No, Mr. Rodgi, we don't need assistance right now at the conclusion of the matter.
One fact. One fact.
I am the person who's going to.
No, they have no stakes in the matter.
Forget my application.
No, Mr. Rodgi, we'll not hear you when your application. We have to follow procedure in the court. It's a constitutional court.
One will allow
Yes,
us.
Mr. Rodgi, no, Mr. Rodgi. I told you the reason for it. We are now at a stage when the
I am
judgment
not
is
on my application, not that it become influential. I am now only saying
No,
that
Mr. Rodgi, we don't need any assistance at all. We are clear. We had very able assistance on both sides. We don't need any third party
I
assistance.
meant not.
The lawyer didn't get a proper assistance.
So just one
The
thing.
grievance of those who will now be deemed that you have given A party, you have given to B party, that will
That
be.
was precisely asked, that was.
Lord, one more clarification.
What we did that we gave to the government under a scheme.
Mr. Rodgi, there's only one simple answer.
Yes.
With effect from the 12th of April 2019, when we directed the collection of all details, everybody was put on notice that hereafter, the details which you furnished would be subject to the result of the petition. Therefore, in drawing the balance, we did not ask for the disclosure of details prior to the interim order of the court. And that was a very conscious and well thought out decision of the Constitution bench.
Was it the intention of the court to know which man paid where, so that if he pays A party, he will be subject to victimization of B?
Well, the Chief Justice of India's tough questions to the SBI, with the Supreme Court there saying all details must be disclosed and the SBI to disclose all its data. So the Constitution bench hearing the electoral bonds case, hearing over the disclosure as far as the alphanumeric code is concerned. The unique code linking the donor to the political party was not made public, and that is being asked by the SBI to disclose all the details. The bond numbers need to be made public, is what is being said in the Supreme Court. The Chief Justice of India said every conceivable detail should be made public.